All right, good afternoon. We're going to go ahead and convene this meeting of our Health and Human Services Committee. I'm joined by Council Member Sales and Lutke. The purpose of today's session is to follow up on the conversation we had on November 21st, in which the committee had a joint session with our audit committee to discuss a Office of Inspector General report regarding our Office of Human Rights. And we discussed at that session some issues that had been raised and some questions had been posed, which the department has, the team has responded to. And this is a follow-up to that conversation to see where things stand now. There were several issues that arose during that session where Director Stowe discussed some hiring challenges because the council was able to help appropriate some additional positions, still not filling, we know, all the needs, but those positions had not been filled, so we're hoping to get an update on those particular positions, and then an update on the operational improvements that hopefully have been made and implemented and where all of that stands. So, and before I turn it over to Ms. Singleton to just set some broader context, I think it goes without saying, Mr. Stowe, I know I speak on behalf of all of my colleagues, especially us on the committee, and how much we deeply respect the importance of your office and the work that it does. We also acknowledged during our session in November that the council has been very aggressive in passing laws that your team is responsible for enacting, and that you have not received the funding support as you've requested over a number of years. But within that, there were still some administrative opportunities that you acknowledged could and would need to be addressed, and so that's what we're going to be spending the bulk of our time on this afternoon. We will not be getting too far into the budget because obviously we will wait in just a couple of weeks for the executive to release his budget. So for purposes of this afternoon's discussion, we're just going to focus on those administrative and operational changes that the team has made. So with that, Ms. Singleton, I'll turn it over to you to make any initial comments, provide any context, and then we'll turn it over to Director Stowe and his team to make some comments as well.
Sure. I don't have anything to add to what you shared, except that there are some related materials that you have. The Standard Operating Procedure Guidance has been shared with you, as well as the Office of Human Rights Intake Log. And so those might help address some of the questions that you have.
Great. Director Stowe, I'll turn it over to you to make some opening comments, and then we'll sort of walk through the packet and get the updates.
First and foremost, let me again share my appreciation for this opportunity to come back and begin to continue the conversation on what we're doing in the Office of Human Rights. We take the opportunity, and this has been evolving, I have to admit that, in terms of trying to see the bigger picture relative to ways that we can, in fact, improve, and also to acknowledge what we have done. That's to say then to get us to this point in time. With me is our compliance manager, Loretta Garcia, and in the back here is our coordinator, Anis Ahmed. He's our office service coordinator in this area. Let me start off by saying that we took to heart, as I said, as we evolved, to a point for which we said to ourselves, can we in fact do better? Look at ourselves critically. And we did. I think the suggestions by the OIG's office were helpful. We went back in and looked at those things, particularly the standard operating procedure, which I maintained then and maintained even now was not something that many of us had. As it turns out, I did share that in my colleagues around the state of Maryland, no other organization has a standard operating procedure as far as investigations are concerned. All they were utilizing the law, as it were, in their particular areas to guide them through their process by which they made investigations. However, what it did do for us, and we did, by the way, include all of our staff persons in this process, we literally went through every step of our actual investigatory process from the time someone knocks on our door or makes a phone call to our office or sends us an email, all the way to the end of the process by which we, in fact, make some conclusion about their complaint or otherwise their disposition of that complaint itself. And in doing so, it brought to light a lot of questions that our folks had, and there were some inconsistencies, I have to admit that. But what came out of it, though, as a result of us going through line by line, was an appreciation of what was being done, when whatever it was being done needed to happen, and then the follow-up to that particular step. as well. And so what you have before you then is a completed standard operating procedure for investigations. It includes, as I mentioned at the very beginning of the process, stating the overall parameters of why we exist in our opening statement in that document. And then following that are the steps that are crucial to going through from point A to point Z of how we conduct the investigation itself. It gives then our investigators a actual roadmap as to how they should go through the process of investigation. And so as we have new folks come to our organization, we now can actually have them with a handbook, if you will, that allows them then not only with the instruction given by the supervisor, but also have this reference document that can actually walk them through the process of how to investigate a case. And that is our core work that we do in the office, and that's why we actually focused on that in terms of our standard operating procedure. The only other things we do outside of that, not only for the standpoint of the number, is our education outreach. Many of our administrative tasks have been taken over by OMB, and so they're involved with the process of dealing with issues relative to purchasing and those kinds of matters. Now, we are tracking those kinds of things in our office, but in terms of the actual facilitation and so forth, that's been done now by shared services. That leaves us then with education and outreach. And primarily, I'm involved with that directly with assistance from my team. Primarily, I try to involve myself in those things so that we can free them up to do this core work we talked about a minute ago. So that is one step, I believe, that is, I think, important to note about what we've done procedurally in the office. The other thing we've done to really, really hopefully grow our office is that now I'm asking our supervisor, in this case, to make real sure that what we're doing is having learning take place in our office. What I mean by that is this: we're trying to free up time in her schedule to allow her to then work one-on-one with investigators. So there's an opportunity then to have that give and take, particularly those investigators that are younger and less experienced to this particular kind of work. And let me just say this: an investigator is not an investigator is not an investigator. While there may be similar skill sets, the nuances and the complexities are very, very different in the work that we do as opposed to maybe other work that's being done by people who have the title of being an investigator. But as a result of all that, I think what we've done now is allow then some one-on-one time for each investigator every week to meet with the supervisor and to go over his or her caseload at that time. If there's any problems or concerns they need, in fact, to go and directly to speak with her about, then they're able to do that in the context of that kind of concentrated time. We think it's going to pay huge dividends as we go forward. Each now has also a new tracking sheet, a tracking log, if you will, that allows them to make real sure that we're tracking that case all the way through the process. So at any given time, I need to ask someone, where are we with case X, Y, and Z? We ought to be able to tell from that log where that case is and what process it may be in at that particular point of time. That will also help us, again, make sure that the age of those cases is always monitored, so we get an idea about where we are, how long it's been with us, etc. We have a unique set of circumstances in the instance that we work very closely with U.S. EEOC. In many instances, we have what we call a referral relationship, a 706 agency relationship that allows then this deferral of cases then to local agencies across the country. And so if a complaint comes in with an address within Montgomery County, generally speaking, that case is referred then to us for, in fact, adjudicating that particular case. As a result of that, we get sometimes cases in our inventory that may have sat in their inventory for some period of time prior to them having gotten to that particular case to do the transfer. And so as a result of that, we are going to now better monitor when it actually comes into our inventory, because we have some cases that have been sitting with them, for instance, since 2022, as an example. So if we don't get it until 2024, then obviously that case has been sitting for a minute. I'm so sorry, let me get back to the regular vernacular. It's been sitting for a while. And as a result of that, we then allow there to be a real disconnect with the reality of how long that case has been in the system. As far as the actual complaint is concerned, it's been a long time, no doubt about that. But clearly we want to make sure that at least we are accountable for the time frame for which it actually came into our inventory. We obviously could not be accountable for what happened before then. And so now we're trying to sort that out, to have a position then that we can in fact see that date and mark our calendar, if you will, mark our clock, if you will, from the time it actually comes into our inventory, so we can evaluate our work against then the work that may have been done by someone else. And so we're finding ways that we, in fact, can also enhance the skills of our investigators, but also give them the tools that they need to make really sure that they can do the best job possible. As a result of that, we also are migrating our current case management system to an all EEOC management system. That will allow us not only to do employment cases, but all cases, and be able to have a case management system that's responsive to what we need. What we had in place was a system called Time Matters. We've had it for years, but we had less and less opportunity for, again, support for the system, because it was one that was outside of the county government domain. And so as a result of that, we always had breakdowns, we always had issues or concerns. While some of them got fixed, some of them did not. And we always was a source of, again, frustration for our investigators. So we hope then that as we migrate over then to the ARC system, that's what it's called for EEOC, that we'll be able then to try to deal with some of those issues. And so we'll be able then to address the issues relative, again, to the tools that we think are important to give our investigators. And then the issue of training comes in. That was the big issue the OIG pointed out. We have what we call a mandatory requirement for basic EEO training that was being done by EEOC. It was actually a 40-hour training that all of our folks go through. As a result of what has happened more recently, that training is no longer available by that particular organization. And so we've got to find ways to augment that. And we do have other partners throughout the state. State of Maryland, as an example, has offered that when they do their training for the state employees, and I mean those who are coming from the Ohio Civil Rights Commission, that they will include us in that training. And so we're trying to find avenues for folks to be able to do that. Other folks who are in the advocacy business, enforcement business, also are doing training as well. So we're trying now to put in place an inventory, if you will, of all of the courses our individual investigators have taken. So when we meet with their work plan and have an opportunity to talk about that performance rating sheet, that we look at what they've taken and what is in fact needed and required to have them have a well-rounded point of view of the work and the skill set itself for being a top-notch investigator. We think it's going to be very helpful, not only for the investigator, but also for us to know what our folks in fact need to have and what training they've already completed. In the past, what we've done is require the training, but we left the training as to what they would take up to them. Because what we said in those days was the fact that you may know better what you are weakest in. And so please open up the entire book of opportunities, not only from across the country, but also through our federal partners at that time. What do you see out there that's available that might speak to that weakness? And we'll make sure we find a way to fund it, to pay for it. And so we've moved from that now to more of a mandated kind of situation where we're saying then that you need X number of hours in the area of housing, in the area of employment, area of public accommodations, et cetera, so then that you are fully skilled in those very basic areas of EEO law. And so that's the approach we're doing now for our training that's starting now in this round of, again, performance ratings that are going on right now. We're putting that in so people will know about that as well. So the other area that I think is important to know is about this issue of how long cases are staying in our inventory. And so again, with these opportunities we put in place for investigators not only to be aware of where their cases are, but also those of us in the management side as well. And so we're tracking that in terms of the year. In fact, they came into our system and seeing how long it's been there and asking the question, why is it there? And not waiting till the end of the quarter, end of the year, whatever, to say why is it there, but all along the way, what's going on with this case? Why is it not moving? Are there problems that we need to know about? Can we intervene? Can we help? And try to find, again, ways that we are meeting the needs of the individual complainant and also the respondent to make sure that we're doing it as expedient as possible, but also as comprehensive as possible. Because at the end of the day, we want a well not run, but well operated and well concluded kind of investigation. And so that's our ultimate goal. So I think, Mr. Chairman and members of the committee, I think those were the basic areas that folks had a concern around. You mentioned the issue about our employees, those that we were in fact looking to recruit and to hire. Again, our compliance manager working on that for us, and as in the interview process right now to hire the one opening that we had since December of last year. And now we also had actual resignation that was part of a actual retirement. And so we're going to actually try to hire 2 people with this interview process that we're going through right now. They'll take us back up to our full complement of 11 people. Again, 7 of those folks are investigators. The other 2 people are administrative, again, my compliance director and my OSC, and then the other 2 people are myself and another OSC in the department. So that makes up our 11 folks who do the work. And I believe what we're doing now beyond that is also evaluating each individual task of our, again, supporting staff as well. All utilizing our OSCs in the best possible way. And we're evaluating it right now to make sure that we think we are utilizing them to the max, but again, can we sort of wring a little bit more water out of that rag, right, to see what we can do something in terms of that. So we're hopeful to be able to look at that kind of analysis and come back with what we think is going to be a plan that will work for everybody concerned. But we're happy to report that we should have, after next week, completed those interviews and be ready then to make selections and get those people in and hired on board. 2 persons coming in, they'll be investigator 3s.
Great. Well, thank you for that update, Director Stowe. I had a few questions, and then we'll yield to colleagues. We'll start with Councilmember Sales, followed by Councilmember Lukey. So I appreciate the response. Could you be a little bit more specific in terms of the benchmarks that you're hoping to achieve moving forward on the time frame for the investigations? Now, acknowledging every investigation is different.
Yes.
And I did not focus enough on the fact that with the transition of the EEOC cases to your office, you're at the mercy of however long those investigations had taken to that point. I acknowledge that. But many of the investigations are initiated from within the county and from within your office. But what are appropriate benchmarks? What is a reasonable expectation for a county resident that approaches your office? And just walk me through basically what that process looks like. They reach out to your office with a complaint. Take me from there, and then, in your opinion, based on these reforms that have been done, how long is a reasonable time frame for these investigations to take?
We are going to really look at what reasonable actually is defined for us with our current staffing and our current level of experience. I have tasked our particular team that within 1 year we should close the case. That's a very aggressive kind of goal, but it is a goal that I think we've got to work toward meeting. What we will find out is whether or not the SOP that now has time frames. In other words, again, when you call and in fact bring an investigation to our attention, we've got days. We've got 5 days to move on that. We've got days to move on the next thing. We've got days to move. So in other words, it's not just sitting there waiting for something to happen because either there's been no response or there's been a lack of response. We're not waiting on that anymore. We've got in place, if they have not responded in a given period of time, we move to the next step of the process. And so we think that that will allow us then to meet as close as we possibly can that time frame. We will find out, because again, in earnest, we're doing it right now. We'll find out whether or not that's reasonable for us with the level of experience that we have. Again, we've lost some very, very, experienced folks, replaced with people who are trying to learn our system. But again, we believe that we have now the kind of tools in place that will help us get to a place. And we find out that if we can't make that 1 year mark, Mr. Chairman, members of the committee, then we'll back up a little bit and say what's now reasonable for us. But we want to at least set the most aggressive kind of goal possible to get back to a place where we believe in that the credibility of what we're doing is intact and people have some sense of their case being addressed, and more importantly, they get some answer. Because at the end of the day, people just want an answer. They want some sort of end or conclusion to that. Now, I will say, to your point, and that you've already, again, taken that point into consideration, I do want to add one more layer to it, because not only and you had some sense of that, I believe, when you made your statement, but not only when we get cases from outside of the organization, and we get them also from the state of Maryland as well, not so many, but we do get some from time to time. What we don't know is what has been done with that case up to that point. So in many instances, we get to go back and start over and actually reinvestigate the whole case itself, including intake, because maybe something was left off that was important to our process, as it turns out. And so that, again, is more time involved as far as that's concerned. The biggest issue that also hinders that 1 year mark, and we've got to figure it out, is how we deal with intake. Because there's the other part of it that really causes us a bit of a challenge relative to each investigator, because each investigator takes a turn doing intake for the day. Now, the day just means that they're on the phone. They are going to the website. They're going then to 311. They're going wherever it is to pull back the information to find out what has happened during that period of time that they are, in fact, to have intake. But once they have that intake process, then begins the intake process. because now you got to make real sure that what you heard is correct, particularly if it comes in by way of online or by way of telephone. Ma'am, sir, is this what you meant by that? Can I get additional information? This, that, and the other. All it has to happen and be in some sort of form able then to be assigned then to an investigator. That takes time. An intake, as an example, and staff tells me this all the time, it can be from 5 minutes to 35 minutes. If somebody's really, really emotional about their particular situation, it could be an hour. So we just don't know how to deal with that from time to time. And remember now, when they are engaged in that kind of way, they're not investigating a case. And so as a result of that, then we've got to work that through a little bit. We've got to figure it out. Do we have capacity that we're not utilizing in some important kind of way to sort of reshift things? We're looking at that right now, looking at OSCs for that purpose, just trying to figure out, can we augment that in meaningful kind of ways that might free up then our investigators to do the investigation part, period. Not everyone, a lot of my colleagues, particularly those who come from the state of Maryland, then generally around the country, have dedicated persons doing that task. And so therefore it frees up persons in that regard. What we've got to do, as I said before, and you made a statement up front relative to looking at administratively how we can, in fact, maybe look at things more effectively, we're doing that. So maybe there's capacity that we're not, again, utilizing in the right way that might give us that free. But I want you to understand then that not only do I have 30 cases, I've got 30 cases and intake. And intake. That, again, work simultaneous. And I've got to kind of figure out how we prioritize that. But again, the purpose of, again, having meetings with the supervisor every week, the purpose of, in fact, having now time frames for every step of the process, we're saying to our investigators, this ought to help all of us know where things are. But more important, to have that particular complainant, because in that process of the SOP also are requirements to be in contact with the complainant to make real sure that he or she knows what's going on with their case as well. So again, we kind of looked at all the areas that we thought we could improve in, right? And went back in and said, okay, now not only do we want to put it into our system, let's make real sure that we have accountability. Let's say then that how much time is it realistic for us to be able to do these tasks? And that's how we determine whether it was 5 days or 2 weeks or a month. How can we get this done in the most efficient way, not taking again forever, but making sure it's realistic for us to do with the resources that we have. And that's how we, in fact, came up with the actual time frames that you will see in the SOP. I hope that's...
Yeah, no, that's helpful. 2 final questions for now, and then I might get back in the queue depending on what my colleagues ask. But one is, so another component that was a focus of the investigation was the organization of the files and being able to pull things easily and being able to track things. When you describe the change to the new software platform, can you just go a little deeper on, will that change in software address some of these filing challenges that you had before, or is that a separate response?
It's a separate issue, but that was before. We have addressed the filing issue. And so what we've done now is the area for which was looked at. We've gone back through now, and all those files are in place in the right way, in the right sort of form. We also have gone back through, and the compliance manager has gone back through and make real sure then that what's in the file is appropriate for that file. And so what anybody looking at the files needs to understand is that, and you said it a little early on as well, is that every case is different. So you may not have X in that file that belongs in a different kind of case because it has different bases for which it's being investigated. And so one has got to know kind of what the case is about to have an understanding about what should be in that file. But went back through all of those files, and most of those were closed cases, by the way. Went through all those files and make real sure that they were intact. And those persons who are in place that are investigating the case at that time, I'm now requiring all of them to keep their files. To keep their files in their office and file them so we know where they are. More important that the investigator knows where they are. And so again, we have a chance then to have those cases brought forward for review, for questions or concerns. We know where to go because Jim Stowe was assigned that particular case. It is in his office. It is in his file. And so we are now requiring persons to be able to do that. At the end of the process is a stage or step that causes us from an appeal standpoint to have that file in place for 30 days. That's part of our law. And someone has 30 days to, once they receive our determination, to file an appeal. So those cases are kept separately from those that investigators in fact are involved with. We've got one of our other staff persons, our OSC, who actually does that work. And so those files are kept separately. And as they in fact, the term comes in, 30 days is up, that file comes out, in fact, goes to the final filing, and that case is now part of history. So we have done what we believe we needed to do from the standpoint of fine-tuning our process, but more importantly, holding all of ourselves accountable for where those files are at any given time in our office, in our inventory.
That's helpful. Final question is more of a comment than a question, but I think moving forward, what would be helpful for our committee, and I think for you all as well as the executive, is if we have to obviously not in any way, shape, or form touch confidentiality issues or cross that line. But at a macro level, I do think there's an opportunity for you to be able to report with some degree of specificity, for example, how many cases you all received this month, the following month, the next month, and then, establish a benchmark that lets the committee and the executive and our community know what the status of those cases are at a macro level. I'm making this up for illustration's sake, but let's say between November and January, you got 30 cases, and 10 of them were referrals from EEO or the state. 20 of them were originated from Montgomery County. They have been assigned to an investigator, and they are ongoing. And then, you go from there to let us know how many of those 30 within 6 months and a year have been closed and how many are kept open. Just establishing some macro level data that I think would be helpful and help us know, because we're not going to get into the weeds. It's not appropriate for us to get into the weeds. We won't be in your offices every day, but it will help you tell your story when you come back before this body. I used to do that when I was an executive branch agency, and I think that would be good moving forward. So I yield now to Councilmember Sales.
Thank you, Mr. Chair, and good to see you, Director Stowe and Ms. Garcia and Mr. Ahmed. As we know, we're in the middle of challenging times, and a lot of our diverse communities are going to be calling on your office now more than ever before. And given that not all jurisdictions have this incredible office, it further amplifies the importance of the work you do and how much we value the work you do, and how other regions are going to be looking at us as the blueprint for the work that we do and how we address complaints and resolve them in a timely fashion to be responsive to our community. And so I appreciate your updates about the actions you've taken to address the findings and recommendations in last year's OIG report, and just have a few questions to ask about some of the ongoing work to ensure that we are better understanding the volume of work that you have and the process to become more efficient in the office. And so I know that's, it hasn't been long enough since you've started revising the process. And so when do you think you'll have enough data to be able to determine how performance has improved with the new SOP?
I believe that if we probably look at the next 2 quarters,
Okay,
we should know.
6 months.
We should be able to know for sure whether or not we've got something that really is valuable. We already are seeing, by the way, improvements in the work product already, because this guidance has given folks again those parameters that they weren't there before. Case in point was that we would again send when somebody makes a complaint. Before that complaint goes into quote our system, they've got to come in and actually have a signed complaint before that goes forward. And sometimes persons come in and sometimes they don't. But according to the law, they have up to 1 year to do that.
Okay.
And so you may be sitting on some case, and somebody's got to monitor it, by the way. You just can't be sitting out there and say, well, whatever. But we've got to monitor those kinds of intake opportunities, and these calls at that point in time are called inquiries. But these inquiries come in, and so somebody's got to monitor that. And so we're already seeing areas where now that we are trying to put a little bit more emphasis on getting an answer back from folks. The law does say what it says. We can't change that. What we can do is try to put things in place that allows us to begin to be in more contact with that individual as an example. So those are things that we're doing that we're already starting to see some impact. But to your very specific question, because now we'll have 2 brand new people.
Okay.
They'll be coming in as well. And so that's going to also impact,
Yeah.
the level of performance and the level of productivity as well. So we will have then that period, again, 6 months to be able to look at this period and say to ourselves, okay, now, and even if it requires any tweaking at that point in time, as we said early on, we'll know that as well. So that's the time period I think will be helpful to us.
Okay. And so, given the OIG report, how will you evaluate and refine the process over time? Once you have those 6 months, will you use the criteria that was recognized in the report, or are you looking at other criteria to evaluate efficiency?
We're going to use our own criteria.
Okay.
And that is the absolute guarantee is a little bit too strong, but the commitment we're making to the public. That when your case comes into our system, it then will go through the series of steps necessary to follow the law, but also to a timely completion. If we can't do that, that we in fact make real sure that you are aware that case is, for instance, more complicated, as an example. We may not make that year turnaround as an example, but we need to make real sure we are communicating that to individuals. So that's the criteria, I think, then, Councilman Sales, that will be really important for us to make real sure that we can say that. And so as we go through, even with what's been asked of us, for this committee is concerned, we're looking at a given period of time and looking at cases coming in, looking at closures, looking at where those cases would have come from, whether it's EEOC, whether it's the state of Maryland, whatever the case would have come from. Given that opportunity to kind of see the progress, you all will be able to help us see that as well. You can follow how these things are kind of moving through our system.
Okay.
And so that's the criteria we want to use. That we think that's more direct to us. I think the overall suggestions given by the OIG really spoke to a much broader kind of piece. I think we tried to address that. But now we want to drill down to very close to what we believe are the real specifics. And that is your case and my case and every case that comes through that persons can rely. They'll get, again, the right attention in a timely fashion.
Okay. And how does the intake log compare to other best practices in other offices? Do other offices have intake logs?
Some offices do.
Okay.
All of us have something.
Okay. Okay.
It really depends upon the resources that are in every given office. What we found is in our particular case and circumstance, again, our right source is our investigators. What's missing on the intake log? What do we need to know? One thing that we found out, the OIG pointed out, was this issue of status. That case may have come in, like I said a minute ago, an individual has up to a year to come back and say, I want to pursue that case. Or we don't exactly hear from that person at all, right? But until that point in time, that's quote an open issue for us. And so what we've learned then is by looking at that tracking sheet, we now know where that case is. Now, we've not heard from someone within that year period of time. We're also going to use that same log to close out that case or close that inquiry at that point in time. We've not heard anything back. So that's how we're using it. We think it's going to be effective going forward as well. And as we, again, need to tweak it, maybe, again, it may not be all inclusive. We can obviously can do that because now we're living in it real time. We're having real examples of where maybe we see something was missing. We now can go back in and say, we need to add this, because we need to know that piece of information. But that's how it was constructed. Again, our compliance manager and the compliance team worked on figuring out what those concepts were, what those categories should be. And we think we got a real good document now that they can actually use and be meaningful to everybody.
Okay, and so this new system that you're migrating to,
Yes.
does it have a checks and balances component where if something is taking longer than anticipated, it will trigger a reminder to the investigator? Is there any sort of feedback loop to ensure efficiency?
I'm not sure that there is with ARC.
Time, as he said, we were using, can you hear me?
Yes.
We were using Time Matters, which is a billing
No, you pulled a
system,
little bit.
Move closer.
There we go. There we go.
That's good.
which is a billing system. Both systems have pluses and minuses.
Okay.
The EEOC is more robust in what we can track electronically because we can upload documents in there. So when I'm reviewing something, I can go in and see when things were submitted into the system, and review the respondent's position statement or the rebuttal statement to do a
You
better.
can see things in real time, but there's no warning
No. So
component.
Time Matters did give a trigger because it was a billing system, but EEOC doesn't have that sort of trigger. And, like I said, we can go into it. The investigator who's assigned to it can go in, I can go in. The ROSC for compliance can go in. So we can track it that way. But it's really going to be the manual tracking inventory sheet that's going to track that.
Okay.
And we've always been doing that quarterly. It's just now we're tightening up the process with some recommendations from OIG.
Okay. And you mentioned that you're hiring 2 new people to get back up to 11 full-time employees. So what will the new caseload ratio be once these new staff are onboarded?
Well, they generally carry about 30 cases. So the level 1 investigators, I try to assign them a case that has only one basis or one basis plus retaliation. And then as level 2 will get them a little bit more complex cases. They'll have 2 or 3 bases. The level 3 investigators get the more complex things. Employment cases tend to be more complex than housing and public accommodation.
So that-
Generally, when we get those issues in, it's just one thing. They have a problem with the stairs, or they didn't get a refund and somebody else they know got a refund, that sort of thing. Those are fairly easy to resolve. Those things can be done. There's the tracking time, it takes, let's say, 30 days to get a signed complaint, up to 1 year. And then we give the respondent 30 days to respond with their position and answers to our questions. And then we summarize that and send that to complainant for their rebuttal. That can take, again, another 30 days. Now, sometimes we get complaints from people and they themselves have asked for additional time. So, that's the kind of thing we need to factor in. The SOP is tightening it up so that we give only an extension for 2 weeks. And then we move on. So that allows us to figure out if there's no response, we follow up, and then we can close the case out. So that, in terms of timing, that will help with the numbers.
So is the average time is 1 year for cases to be closed?
That is our goal.
Okay.
That's our goal.
Okay.
The employment ones don't meet that, but
Oh,
we can
okay.
probably do that for housing and public accommodation.
Okay. I will yield and go back in the queue.
Great.
Thank you.
Thank you, Councilmember Luke.
Thank you. All right, I apologize for having my glasses on today. So I need to take them on and off because otherwise I can't read my own handwriting. So that's why they're coming off. So when Councilmember Albornoz was talking to you about the different things that have been done now since the time we were all together in the fall, and now it sounded like you thought that all the things that OIG had raised had been met and dealt with. But then when you were answering Councilmember Sales's questions, it sounded like you needed 6 more months to figure out if it was being met. So I just want to make sure I'm understanding, because the questions were different, right? But I want to make sure I understand where you are on all of that. Like, should OIG come back today? What would they see based on what was in the report for 2024 and what was in the report from 2020?
What they would see is compliance with all of the suggestions that they made. That's what they would see. What I heard Councilmember Sales really ask, though, was how would we know how effective they were relative to having now with them in place, what changes we would see, what progress we would actually. So that's why I heard that question very different than that.
Yeah. No, that makes sense.
And so with that in mind, that's why I mentioned again, and particularly now with 2 new people coming on board, they're not going to be up to speed today or tomorrow, right, with whatever we have in place. And so I think that they would come, to your second question, they would come and be able to see, and matter of fact, they will have a package that checks off the things for which they thought were suggestions and for us to do, and we can say we have complied.
Okay. And then like, I know that it's my understanding that the things that the OIG report includes aren't really suggestions. Like, these are things that have to be done, right, in order to get an agency to where they are supposed to be in terms of addressing underlying issues, right? And so I just, if I am misunderstanding that, that may be part of why I, am struggling with that a little bit, because I don't view them as suggestions. I view them as requirements, right? And that, like, these are things that we have to do. And that was, I think, part of why it was challenging in the fall, because there had been a previous report of these are the things that you have to do to get this to where it needs to be. And then they weren't done, and then they were the same ones, right? So I just want to make sure that you all are viewing them as required, and that you're making sure they're getting done, which it sounds like you are, and that we'll see how the measures that you put into place to help with some of that functionality actually play out, because you need time to see how they are working. Is that accurate?
Well, to some extent, Councilman Lukey, the language in the actual report says recommendations.
Okay.
It does not say requirements.
Okay.
Now, if they are requirements, then put the word required in there, and therefore,
Okay.
in fact, it's very, very clear, but
Sure.
it is recommendations.
Okay.
And so, in looking at that, we took them, however, as requirements.
Okay.
And we have put in place, again, trying to meet those recommendations vis-a-vis requirements.
Okay.
So then that, having looked at those particular things, as I mentioned, that it was clear that, and if you take a step back, can you do better? Yes, we always can do better. Yes, we always can improve, right? And there's some things for which we have capacity already in our office to do that. And so we stepped back and said, forget about anything else, folks. Let's look at this. Let's look at an SOP. Let's look at, as a matter of fact, we've also looked at our regulations as well. Went to those, again, word by word and statement by statement. So again, our folks will understand what it is that they're supposed to do, know what things mean. And so we took that as that. But again, I want to make sure the record is
Right.
clear that it said recommendations as opposed to requirements.
And I know you were pointing out that, you use an investigator is not an investigator is like, but the point being, they're different, right? Depending on what it is you're focused on, what your content area is. And that's true, but at the end of the day, the law, the basic law undergirding all of it, like, they have a prescriptive area of content they're working in, and it's going to be different for housing versus employment, right?
Yes.
But they know that they have to follow a rubric of, this is what constitutes a violation, so this is what I'm looking for, and okay.
Yes.
And respecting that, again, with the federal government not functioning right now so well, that's a polite way of putting it, that you don't have the training availability there that you once had through the EEOC, and that there's variability in people's skills as they're coming in to work for the office. What are like, as you're hiring right now, what are the baseline qualifications that you're saying, these are the absolute must-haves for the folks who are going to be these investigators?
I'm going to turn to Loretta. Let me, hold 1 second. I'm not sure we can do what I was getting ready to ask you to do from a confidentiality standpoint, because the interviews are going on right now in terms of sharing with you what's in that spec. Am I okay to do that? I don't know.
So well, let me put it to you this way then.
Okay.
Can you send us the listing for those positions that you're hiring for, because they would have been publicly posted, right, somewhere, and so
Yes.
and it would be useful to know whether what you've put in there now, after going through this process, has it changed? Has it been updated since what has been when you've hired other investigators over time? That would be useful to know.
Councilman Luke, let me do this. I'm clear now. We can.
Okay.
In terms of the actual posting announcement, can you speak to that?
Okay, we can provide that.
Can you speak to it right now?
So in the last, Chairman Albornoz mentioned that he had been allocated 3 positions in 2021. So we had 4 legacy positions. Those were level 3 investigators, all had been here 15-plus years. In fiscal 21, we had so three new positions have been allocated to us for investigators, and they capped out at level 2. So in July 21, we had one added. January 22, we had one added. And July 22, we had another one. Those are level 1, 2 positions. So we were up to 7 investigators by the end of by January of 22. January of 23, we were up to capacity. We had all 7 positions filled. And then we lost one in June of that year and another one in December of 24. So that's what the 2 vacancies were. And then we hired one in November to fill one of those level 2 investigators. And then we had a level 3 investigator retire in January of this year. So out of this posting, it's a level 3 posting. The prior ones were for level 2, so it's a little bit different.
Okay, well, you could provide both. Presumably, there are base minimum requirements for each one that you're like, if you don't have these, we're not going to be able to hire you. So that's what I'm getting at, knowing that you have different tiered.
Real skill sets that
Sure.
we actually put into the posting.
Right.
Yes.
The best thing we can do is get people who can write well. There aren't a lot of human rights investigators out there walking around looking for jobs, just because this whole industry has been shrinking for a decade. But so when we were looking to hire, we got 2 social workers who had, rapport with people. They've done intake, they've done reports to courts, that sort of thing. So those are still with us. Those are working out well. The police officer who had done investigations, not so much. But so that's what I'm looking for primarily is good writers, but also people who have worked with in human interactions and people who can work with difficult people, because sometimes our people, everyone's been stressed in some way. They've lost a job, they've lost housing, they've not been treated well with a retailer or whatever it might be. They come to us in a state of frustration.
Sure.
So we need someone who can deal well with that. And then somebody who can meet deadlines. There are many jobs where people meet deadlines. Like I said, writing, the determination we write is much like an administrative law judge's determination. And depending on the issues, you have to address each issue, otherwise it becomes appealable.
Right.
So they're not lawyers. We did have a lawyer, she left, but so I'm just looking for people who have good judgment, good people skills, good writing skills. And then we can also use languages. So the preference, it's not a requirement, but the preference was for people who spoke 2 languages.
Sure.
So we got, if you want the numbers, we got, I'm not sure how many applied for this posting, but we got 11 that were put on the eligible list. And then I went through, and some of them had too much experience, and we don't have the budget for that. I learned from the past recruiting that we would make an offer, and they would say it's not enough money. We just can't offer them salary that they're making. We just have the budgeted amount. So, so we're interviewing 6 people. I interviewed 3 yesterday and 3 tomorrow.
In terms of the case management system and that now you'll have this better compatibility with the cases you receive, what versatility is there in that, or separately in being able to track, like, once the case comes to your doorstep, appreciating that you can't track what happened before. You may know when the other agency opened it before it was transferred to you, but really the clock ticking is when it comes to you, because you do not have that capacity to have managed prior to then. But, like, do you track how quickly or set a requirement for outreach to the complainant? And then calendar for follow-up, and what is the frequency with which you must engage with the complainant in order to make sure, the train stays on the tracks?
We're giving ourselves, again, in the SOP, we're giving ourselves then 5 days for everybody, regardless of when it comes to our system.
Okay.
You need to hear from us. We've got your case, ma'am, sir, or we received then your signed, your inquiry. We're getting back with you. 5 days is what we set for ourselves. We think that's realistic for our groups to be able to get back with people.
Yep.
And so that's for anybody coming into the system. So we're not relying upon the new case management system to assist us with that.
Right.
The other thing I would say, too, is that as part of the process of moving from the one area that we put special attention to in the SOP was the communication with the complainant.
Right.
That was an area that I have to confess we can do better. And so we're trying, again, having these time frames in place that give not only guidance, but these are mandates, again, going back to that word, right?
Right.
These are mandates for the investigation. These are not things that are arbitrary.
Right, right.
For our investigators. We want to be able to see, and if you cannot, again, give us a reason as to why we did not meet that, then we have a different conversation about that. But what we're looking for is that, and this is why it was so important to the committee, it was so important to have everybody involved. So this was not a top level down. This was a combination of all of our thoughts and ideas and creating these time frames. And so we feel we have buy-in from the very beginning. And so the accountability should be also be built in.
And then do you track, for example, you noted that, if you haven't heard back, if they want to pursue the case, right? And there's a host of reasons why somebody might not, for something I work on and still work on that I do as a volunteer, we have to try to outreach 3 times. And we have to use 3 different methods, right? Mostly because we're working with teenagers. And so it has to be phone, which is so old school, email, they might check it, text message, tend to get my best responses that way, right? But that's the demographic I'm dealing with. Do you track when you're doing that initial outreach to let them know so that you may leave a message and people may not call back? And do you have like a protocol for how many times there should be an attempt to connect, and then, perhaps 30 days before the expiration of the 1-year period, a notification out, like, we have to know by X date. And then on day 366, the case closed if you don't hear from them.
No. We don't have that particular piece in place. What you just described happens once it becomes a complaint. Mm-hmm. We've actually had an interview or a engagement with that particular complainant. They've gotten a letter from us saying, we've got your case. Mm-hmm. It's now signed, this, that, and the other. And then you've got then a period of time to sign that case. Now we're engaged in a formal kind of relationship. Mm-hmm. Inquiries, we have 400 or 500 of those that we couldn't, and this
right.
An inquiry is just a call came in, I think this happened, there's no follow-up from that person. So no, now what we're trying to do better is tracking the number of those that are coming in, because again, we've got to at least take the phone call, right?
Right.
But in terms of pursuing that beyond letting them know what's required in order to file that case, right now that's not part of our protocol. However, if he or she then says that I have filed my complaint, I have a signed complaint to you, or at least the inquiry has gone in the intake process, we've had a conversation. Now we're giving you then 30 days to respond back to us with a signed complaint. Mm-hmm, mm-hmm. If it's not signed, then
right.
And now
right.
we're trying to again get to a point where we're moving the cases, and so we're trying to have as infrequent follow-ups and follow-backs as possible, but at the same time making real sure, however, when someone is engaged in the process of trying to explain themselves, we try to work with people like for instance,
right.
a lot of our persons who don't speak English as their first language, right. We've got to work a little bit differently than we do then for others that are not in that situation. We have only one now Spanish-speaking person. We had 2. So now all that's coming in to this one investigator. And in this case, for instance, that's a whole nother level of involvement than when we said 30 cases. Now those cases are, again, they blow up because now the issues are so very different. And now luckily we got someone who can actually speak the language, so at least that's not a problem. But they're more complicated. So if that's a point that you want to look for us to kind of pursue, then just share that. But right now, to your very basic question, if somebody makes a phone call and does not follow up, right, then we don't have a protocol right now. Am I correct about that? We don't have a protocol right now that would say, I'm going to call Jim Stowe.
Right.
When, you know, as you mentioned, when 30 days are left in that opportunity for him to reply to me.
Right.
We don't have capacity for that, we don't think.
Okay. Yeah, I'm just, I'm just sort of thinking, like, I was a trial lawyer, so you can work at a big firm and have all the bells and whistles and somebody tracks your stuff for you, or you can work in a tiny boutique firm like I did, and, you're using Google and you're doing it yourself and you're calendaring your own things and you're staying on top of your stuff. So, like, for me, I raised those things as a way to help say, are you thinking about it this way to help streamline your work? And then, when you have 500, 400 inquiries that come in, but only this much is going to go down in the funnel and actually be a case, how can you take the noise that's up here that isn't going to go anywhere and document that you did the things to try, and then be done with those so they are off your plate? Because if people aren't going to follow up or there's no there, then you don't need to have that hanging over your caseload, right? So, and you should have a process for saying, and this is where that ends, because the people are not engaging and we can't move anything with this, and that would help to streamline some of your work. You mentioned in the cases that get transferred to you, you have to reinvestigate everything. And I wanted to know, is there a difference between the cases that come from the EEOC versus those that come from the state as to what they do provide you when they're transferring a case or referring a case over for you to handle? And then is there a process by which your team engage with whoever previously had it at the other agencies with a set group of things that they should be getting on background from the transferring agency before going out to do your own investigation?
What we're doing now is Councilman Luca, we are working with the folks in Baltimore. It's primarily where we get our cases from through EEOC in our particular district, Philadelphia district. So as a result of that, there's ongoing conversation that the compliance manager has with that person in that process of knowing how many, and most time it's an ask, got 30 cases that are headed your way. Can you take those? And so we have that kind of conversation back and forth. The expectation is that that case comes in with at least the minimum done relative to the intake. Who did it? What the allegation is being alleged? Who are the persons involved? That kind of information.
Right.
And sometimes, and I'd say sometimes to my colleagues, they may be tuning in, to my colleagues, sometimes that's not always intact. And so when I said early on, going back and doing sometimes the entire investigation, what I mean is that they got to go back sometimes and redo the intake because there's something missing that we, in fact, ask for. And we try to communicate that then to the folks who are doing the referral back and forth, so the next time around, they can look for those things before they send them then, to us. But again, it's like anything else when you're dealing with a lot of numbers, a lot of folks, a lot of people, it doesn't always happen. When it doesn't happen, then that particular one may be one that we labor on to find out all the details, because again, it may have sat for a year or 2 years in that same condition. And so now people you're trying to find who are part of that intake process may not even be in place. The business may not even be in place. So a number of things can change, right? And so folks have to work with that, but that's the nature of what we do. We understand that as part of the process. And so in order to try to keep as much of that down as possible, we inform each other, next time, make very sure that they look at this or they check that or put that in place, right? And that helps us a little bit with those ones that don't meet our criteria. And we say all the time, so it's real clear, even with the committee today, we are enforcing the county's law, not Title VII.
Right.
And so we're only looking at the issues that, in fact, we cover here with EEOC. So not sending us anything that would be outside of those parameters, just those kinds of bases that are part of the process here.
Okay. And then I know in the packet on page 6, there's the list of all the bills that are applicable to your work, right? All the local laws. And some of those came before, then the state subsequently did some of their own work in that space and have set up that thing. And so, and I'm not expecting you to answer this today, but it would be great to give back to us sort of taking a look at the things that the council has tasked you with over time, the many things, because it's a long list. What has changed, and I'm leaving the federal government out of this because it's not helpful for any of us right now. What has changed at the state level where there are things that didn't exist before for the state to handle, but they do now, that we started in Montgomery County, but now the state has taken on statewide to handle? So for example, in the landlord-tenant area, there's a lot that has been changed, which I'm very appreciative of. But that sort of figuring out what is something that we started but now has a statewide mechanism for being dealt with. And then the other piece being, and there's a lot of community related work that you all do that's informational and educational and so on and so forth. And then we also have our Office of Community Partnerships here at the county. And so sort of what is unique to you? What are they each doing? What might be some places for some overlap and collaboration, but who within that ecosystem between Office of Human Rights and Office of Community Partnerships may have overlap, and what could be done to streamline that? If you could get that back to us, that would be really helpful. And with that, I'll turn it back over to you.
Great.
Can I just mention one thing?
Yes.
On the back and forth with the EEOC,
Mm-hmm.
the kinds of things that come to us are, they've done the intake and then they send that to us. That's basically all we get. We have,
Right.
sometimes their script is in there and the drafted portion of the complaint that they have.
Right. Okay.
For instance, on a disability case, we need to get the medical documentation proving that there was a disability and that they communicated that to the employer. That's the kind of thing we reach out with.
Right. And and I'm assuming sometimes the medical documentation has been provided to the EEOC and sometimes it has not. And so you are at the mercy of whether they received it or not in the first place.
Right.
And so if
And sometimes we do have to reach back because it's an electronic system, but for instance, the initial investigator might have received some correspondence that didn't get uploaded into the system. So, we'll
okay.
bounce back to EEOC, but we have now the parties' contact information. So generally, we just move forward with it as an investigation.
Okay. But then from the, I guess, on the complainant side, then, let's say they had provided the things to the EEOC. EEOC didn't upload it into the portal. So whatever was provided, they might have in a hard copy. It's on somebody's desk or it's in a PDF that didn't get into the portal. So then you get it absent that information. And EEO either does or doesn't give it to you later, but then you're going back and asking the complainant for the thing they've already submitted because you need it to do your work. But again, from the user experience or from the complainant experience, like that doesn't make people feel good because they're like, I already gave it to, I sent it to Baltimore and I already gave them my medical records. So who's got my medical records now?
That unfortunately happens more with the respondent because the EEOC generally offers an opportunity for mediation. And at that point, if it doesn't mediate, then they decide, are they keeping it or are they sending it to a FIPA?
Gotcha.
And so that's when we get it. But sometimes, if the mediation failed, the respondent will send their position statement because that's what their time frame is supposed to be. And then it transfers to us and the respondent says, but we already provided that.
Right.
We didn't get it.
Okay.
So those are the parties that are frustrated.
Yeah, yeah. Would you be able to, by, fiscal year and say like starting with fiscal year 2020, since that was like the year that the last report came out, or the first OIG report came out. Get us the list of your cases that went to disposition, just a number where a final decision was rendered, and do it by fiscal year, and then how many of those were appealed. Would you be able to provide that? Do you know?
We have been, since the RIFs in 2010, we've been providing quarterly reports internally to the
Okay.
Human Rights.
Is that something you can get me?
So we can get those. Now, how many went on appeal? Those just show the closures. So
Right.
I'd have to go back.
Well, closure doesn't mean there was a decision, correct?
Yes, it does.
Yes, it was.
Yeah, but
A closure is not,
the closure date doesn't show whether
Okay.
there was an appeal and that was the closure, or whether it
But-
was a determination.
there could also be a closure if the complainant decides not to proceed any further, right?
Oh, yes, yes,
Well,
yes.
yes,
Yeah.
but that's still a closure document, whether it settles or goes to court or
Right.
draw the complaint.
So I guess sort of the nuances of those are important, because if it settles, there's no appeal. If you decide not to proceed, there's no appeal. If it goes to trial and there's a decision, you have an appellate right.
So are you trying to get the percentage of determinations we have that go on appeal?
Yes,
Post-determination, because it could be conciliation if it's.
correct.
a finding.
Yeah, leaving out the mediations or any other type of, like, only the disputed things that's what
My
I'm,
sense is it's about 10%. Also, on a previous question, you were asking about the intakes versus what actually goes into the process.
Mm-hmm.
Now with the intake log we've had, and we put that in place before this OIG report.
Right.
We've just made some modifications.
Mm-hmm,
But it's always been my sense that we got about 4 times as many inquiries, as we actually get signed complaints.
Right,
And that's
right.
tracking with this intake
okay,
log.
gotcha.
But your question, though, goes back to, again, I want to make sure we understand that clearly, is actually the number of cases in that time period, FY 2020, correct?
By fiscal year, each of the fiscal years we've,
Leading up to
to now, to
now.
to fiscal year
how many
25.
actually went to appeal?
Post-determination.
Post-determination
Okay.
that went to appeal.
Okay, yeah,
Yeah.
it'll take record by record, but I can get that for you.
Yeah, because generally speaking, you said 10%, Loretta, and I think you're absolutely correct in terms of, it won't be a large number,
Okay,
because that's a process that includes more time for whomever may be involved, but we'll go for that. We'll get it. We'll go.
okay. Yeah, I'm just trying to see, like, it helps to know how long, things take a different amount of time depending on the process they take and the parties involved and the underlying dispute. And, of course, doing the things like the mediations and conciliations, those help. And
it goes
you would expect most things to resolve that way and not have to go on to final disposition and then appeal.
Okay, we can do
Yeah.
that. We can do that. One thing we would add, though, is that the appeal process, of course, is in another agency, Office of Administrative Hearings.
Yes, but you would know when an appeal has been noted, correct?
No question.
Yeah,
No question.
that's all. I don't need to know what office no, but just that the request was made for it to go over to OAH and then,
Great. We
Yep.
can do that.
Great. I took the LSAT about 21 years ago, so a little bit of a background, but that was helpful. So I guess 2 homework assignments. One that Councilmember Lutke just mentioned. We didn't discuss the time frame, but I think just, a month.
Yeah.
Okay. And it sounds like the quarterly reports you're providing for the executive, provided that they are not disclosing any confidential information, that may achieve the goal that I had requested, which was just, macro level numbers on number of cases ongoing, number of cases closed. So maybe Ms. Singleton, if you can follow up with the team and we can get a copy of that, take a look at it, see if it's what I have in mind, what we have in mind. And if it is, then you just have to copy us on what you send to the executive branch, which doesn't create any more work. And then as we go through our budget deliberations, that can be something we lead with and have as a talking point when we meet with you. So I'll end where I started in just expressing our deepest appreciation for your work. Appreciated Councilmember Sales' comments about your work being particularly important right now. And we will continue to collaborate and forge this partnership between the legislative and executive branches because we know how important this work is. So with that, we are adjourned. Thank you.